persons having business before this honorable court are admonished to draw near and that their attention as the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. We're here today for oral argument. We've got 6 cases. We're going to begin with Appeal 22-2655. This is Chen versus Yellen. We're going to begin with oral argument from Mr. Greco.
May it please the court, Your Honor, counsel, and the clerk. My name is Michael Greco, and I represent the plaintiff appellant Fiona Chen. This is a civil rights violation case. As the district court, Judge Johnston, pointed out, a prior iteration of the case resolved any employment discrimination cases. So what remains, and Judge Johnston did dismiss the claims with prejudice, is argument for a 42 U.S.C. section 1985 subsection 3 claim of conspiracy to violate civil rights, and arguably a malicious prosecution under state court. The First Amendment complaint is inartfully pleaded. That would be a significant understatement. It is difficult to read in parts and somewhat lengthy. It does, however, set forth the basic allegations of a racial animus that the appellant submits that she was subjected to by the defendants.
Mr. Greco, I'd be interested in your thoughts on whether there's a statute of limitations issue here, and if there is, when the statute of limitations may have begun to run.
The statute of limitations may have begun to run quite a while ago. Ms. Chen did first learn of the TIGTA investigation in 2009. She did not know that it was ongoing. She learned that it was ongoing. She alleges in her complaint in 2018 through 2020. This case was filed, I believe, in 2021.
2020, I think. Yeah.
Pardon me?
2020, I think.
2020. Yeah. Sorry, Judge. Yes, and the argument that we would have is the discovery rule as well as waiver. The statute of limitations has not been explicitly pleaded. I don't believe in this. Well, not before this court. It was not addressed by the district court. But the discovery of the potential ongoing investigation within the TIGTA arm of the Treasury Department, and subsequently the ECHO, that's another acronym within the Treasury Department, was not discovered by Ms. Chen until 2018 through 2020, in discovery of the original iteration of the Chen case.
Mr. Greco, what's Ms. Chen's best argument that she survives a motion to dismiss under 12b-6, not 12b-1?
Right. Under 12b-6, the best argument is she put forth the allegations of her differential race, her differential national origin. She alleged that she's Asian American and that she is Chinese American, and she alleged that she was the only person of those groups in the work group that she was working with for the Department of Treasury, and that on that basis that an argument that what could be proved, we submit under the allegations of the complaint, is that the treatment that she received and the exchange of confidential information between the NTEU steward with Ms. Chen's superiors and co-workers, Jamie Kilnick and Gail Trier and Rebecca Solano, was targeted to her on the basis of her race and national origin, which is Asian and Chinese American. That's the best argument that I have.
Mr. Greco,
Yes, Judge.
the district court entered judgment on motion for summary judgment.
I believe that the district...
That's an error,
That
right?
was an error, yes, Judge.
Yeah. Well, did either party move to correct that error?
Neither party moved to correct the error. It's clear, Your Honor, from the text of the memorandum of opinion of order that the Judge Johnston was addressing a 12b-6 motion.
So is this just a harmless error?
I would submit that it's a harmless error.
Thank you.
Yes. In any event, we submit that with the allegations of the ongoing investigation of Ms. Chen within an arm of the Department of Treasury, ongoing and never concluded, according to her allegations, and her allegation that she had an adverse effect on her ability to reapply or regain employment within the Treasury Department, that she has made the gist of a constitutional claim as to the deprivation of that potential avenue of employment, that property interest. And so that is, as best I can frame it, under Ashcroft versus Iqbal, Bell Atlantic versus Twombly. We believe that it's, again, inartfully pleaded, no question about it, but we submit that it's been put forth. As for the malicious prosecution, that also is a problematic argument because, as Judge Johnson observed, much of the post-employment conduct that's set forth in the amended complaint is obviated by the fact is negated, in effect, legally by the fact that there never was a criminal prosecution of Ms. Chen. So there's no question that's a barrier as to the Fourth Amendment claims. There was no seizure, no arrest, and the Fifth and Sixth Amendment claims, both of which presuppose a criminal prosecution and involvement of criminal process. I submit that as a matter of state court does recognize malicious prosecution for either a criminal proceeding or a civil proceeding. There was no judicial proceeding, as Judge Johnson observed, against Ms. Chen. However, the ongoing maintenance of an investigation against her, even if it never ripens into an actual case before an agency or a case in the courts, is arguably a civil proceeding on which it's a non-criminal civil event or set of circumstances which could cause her harm. It could cause her the inability again to regain her employment with the Treasury Department. But that I concede that's a less persuasive argument. I couldn't find compelling case law to support that. But primarily, we maintain that under 1985 subsection 3, that the allegations of the amended complaint put forth that there was a conspiracy and it was targeted to Ms. Chen, that at least in part based on her national origin and her racial background, which is Chinese American and Asian, and different from all of her other co-workers, as she alleged, and that we have the gist of a constitutional claim concerning that conspiracy.
Mr. Greco, would any of Ms. Chen's claims against some of the other government employees fall under the rubric of unfair labor practice versus just a claim by her against them in an individual capacity?
That argument, that certainly was found by Judge Johnson. We submit that the conspiracy claim against Lesha Panapinto, in particular, that's alleged, is not strictly a failure of the duty of, or a violation of the duty of fair representation or an unfair labor practice. The confidentiality of communications which Ms. Chen had with Lesha Panapinto directed to her activities and directed to the actions that she was being subjected to and pursuing on her own were intended to be confidential, as alleged in the complaint, and the breach of that confidentiality is not, although it would certainly support a violation of the duty of fair representation, that it's not the exclusive remedy for that. I submit that it would not preempt inclusion of Lesha Panapinto as a defendant in a 1985 subsection 3 conspiracy argument. So that on those bases, we believe that there is the gist of a claim put forth in the complaint as alleged by Ms. Chen, the amended complaint as alleged by Ms. Chen, And I don't believe that those were all entirely comprehensively addressed by Judge Johnston, and to the extent that we submit that the complaint merits another look or leave to amend.
Very good. Would you like to reserve the remainder of your time?
I'll reserve the remainder of my time, if I may, Judge.
Yes,
Thank
you may.
Your Honor.
Thank you, Mr. Greco. We're now going to move to oral argument from Ms. Horn.
May it please the court, I'm Jessica Horn, counsel for the NTU Appellees, and for these first 3 minutes, I'll be arguing that the district court should have dismissed Ms. Chen's claims against the NTU Appellees for lack of subject matter jurisdiction instead of her failure to state a claim. That's because Ms. Chen's claims against her, against the NTU Appellees, her claims that Lesha Panapinto, her union steward, disclosed confidential information about her, and her claims that her other NTU reps failed to adequately serve her interests, amount to claims for breach of the duty of fair representation. Under the Civil Service Reform Act's comprehensive scheme of administrative and limited judicial review, Congress channeled review of such claims exclusively to the Federal Labor Relations Authority, and it would frustrate Congress's scheme to allow Ms. Chen to circumvent FLRA review simply by labeling her claims as civil rights violations or malicious prosecution. Now, the district court declined to dismiss on subject matter jurisdiction grounds, in part because Ms. Chen did not explicitly list a breach of the duty of fair representation among the counts in her complaint. But as the First Circuit said in Montplaisir versus Layton, the court should look at the conduct being regulated and not the formal description of the legal claims. Those are just window dressing. Here, the conduct that Ms. Chen complains is illegal is conduct that is regulated by the CSRA. The CSRA describes a union's duty of fair representation in 5 U.S.C. section 7114A1 as the duty to represent the interests of employees in the unit without discrimination. Here, Ms. Chen claims that the NTU Appellees acted against her interests and instead served the interests of her managers, and she claims that her NTU reps were motivated by racial discrimination. These are claims that the CSRA scheme channels to the FLRA. And in fact, other courts that have confronted claims just like Ms. Chen's, civil rights claims under 42 U.S.C. sections 1985 and 1986, have viewed those claims as duty of fair representation claims dressed up as something else and have dismissed them as precluded by the CSRA.
Ms. Horn, do you want to be heard on that statute of limitations question? Or you can defer to counsel, however you want to handle it.
I think I'll defer to my co-counsel on that issue. As the statute of limitations is I think a 12b6 issue, I'm addressing the jurisdictional issues here. And so in addition to noting that Ms. Chen did not explicitly list a breach of the duty of fair representation among the counts in her complaint, the district court also observed that Chen repeatedly asserted that her case addresses only the time after she resigned from the IRS. But if you look at the specific allegations against the NTU defendants in particular, everything suggests that she is trying to revive and relitigate her the events that led to the TIGTA investigation in 2007 and her resignation in 2008. And I will defer to co-counsel on the remaining issues.
Thank you very much, Ms. Horn. We'll now hear from Ms. Mallory.
Good morning. May it please the court, counsel. In this case, Chen's complaints specifically and in crux alleges that she was subjected to a criminal investigation that began in 2007. She resigned in 2008, and that investigation continued from that time until now in secrecy. She alleges she was maliciously prosecuted when she was referred to TIGTA in 2007 for that investigation, which was into her work conduct, and that thereafter, the investigation, even though it didn't give rise to a criminal prosecution, she nevertheless, because she was subject potentially to a criminal prosecution, that she was being maliciously prosecuted. The district court properly concluded that the key allegations necessary to support her claim were not plausible. Her allegation about a secret criminal investigation reflected unsupported and irrational speculations and conclusions. And the district court, although it more directly than I was able to do, saw within the complaint that he could move aside all of the allegations about employment discrimination or that related to the previous case and focus in on the counts in this case. He did not, I do not believe, accept the findings of fact in the previous case as the findings in his case. What he did do after he moved aside those employment discrimination allegations and focused in on the allegations with respect to the actual counts alleged, Fifth, Sixth Amendment violations, Section 1985-3 violation, and malicious prosecution claims, he focused in on the allegations that were not subject to reasonable dispute, the facts that were not subject to reasonable dispute. And admittedly, the prior litigation has some play in that. The conclusions that the district court drew from Ms. Chen's allegations and his analysis of their plausibility are that her allegations were not plausible and in some cases frivolous. With respect to the Fifth Amendment claim, the court found that no criminal proceeding was ever commenced against Ms. Chen, a fact that was not disputed by her in her complaint at paragraph 125. She concedes that point, and also in her response to the federal defendant's motions to dismiss, she conceded that she had not been prosecuted. She did not suffer a Sixth Amendment violation because, having not been prosecuted, her Sixth Amendment rights had not yet been activated. There was no criminal proceeding with which for her to assert those rights, nor could she pursue a malicious prosecution claim absent a prosecution, an element that is required of a malicious prosecution claim. Counsel, in argument, I believe in response to a question from the court, raised that the state malicious prosecution law might allow a claim for an ongoing investigation against her as a qualifying proceeding. That was not raised in the briefing, so we have not looked into that to respond to that. But I don't believe the law is strong on that case. I believe that there has to be some sort of proceeding, and perhaps it can be a civil proceeding, but this investigation is not a proceeding. If that were true, then virtually any investigation undertaken by an organization, a government agency, a law enforcement entity, would be something that you could bring a malicious prosecution claim just because the investigation is ongoing, and that seems untenable. Finally, with respect to Ms. Chen's Section 1985-3 conspiracy claim, it's not supported by a non-frivolous and plausible allegation about class-based animus. What she does is she alleges that she, as an Asian American, is subject to what is a generalized animus in society, generally speaking. She does not point to any conduct by the defendants specifically with respect to her nationality. Instead, she tries to group them with respect to their nationality or their religious affiliations and say because that subgroup, in her opinion, has some animus toward the Asian race, that they therefore have that same animus. And that's what motivated them to proceed for now 15 years pursuing a secret investigation. With respect to a loss of any liberty under the Fifth Amendment or any of her other claims, it's a secret investigation, according to her allegations. She doesn't know about it. Counsel argues that her damage is the adverse effect on her ability to apply for federal employment or to reapply to this particular agency. But two things. She did not know that she was under this secret 15-year investigation that she alleges. She also did not allege that she ever made an attempt to apply for a position and was rejected. So those allegations, those two allegations, are highly speculative and they do not merit the court accepting them as plausible allegations to support the claims.
Ms. Mallory, do you want to speak to that statute of limitations question? Thank you.
I will. I do recall raising it in the district court. I did not raise the argument in this court. In the district court, our position was, as counsel mentioned, she learned in 2009. It's within her allegations of the complaint. It's clearly out there. She concedes that in 2009, during the EEO part of the case, she learned that there was a TIGTA investigation, and that was the first that she heard of it. She did make an inquiry to an agency counsel about that and was assured that it was not criminal, it was civil, and it was closed. She disputes that now, based on what she says she learned in 2018 and 2020 during the discovery of the case. The federal defendants are the only ones involved in that case. But we do not agree that she learned of this that late. This was something that was known throughout the case. The documentation that she refers to was produced earlier in the case, earlier than 2020, 2018 even. But that's something that was addressed in the district court. It is not part of our briefing right now. We did not re-raise that. We do believe we have a strong statute of limitations argument. Whether it would have been resolvable on a motion to dismiss without accepting some sort of fact in the Chen 1 case as a finding of fact in this case, which might not be proper, I don't know that we would have necessarily succeeded. But it is an issue to be raised if the court decides to send this case back down and allow an amended complaint. Unless there are further questions,
No, thank you very much, Ms. Mallory.
thank you. We ask the court to affirm the district court's decision. Thank you.
Mr. Greco, we'll go back to you for rebuttal.
Thank you, Your Honor. May it please the court, Your Honors. The fact that the statute of limitations was not picked up by Judge Johnston in the final memorandum decision and order, and was not deemed dispositive by that able judge in dealing with this case in the district court, does tend to lend color to Ms. Chen's allegation that she did not know that the TIGTA investigation, which she first heard about in 2009, was actually kept open into 2018 and beyond. She actually avers that she never learned that the TIGTA investigation had been closed, which she submits is contrary to what she had been informed. She alleges that she was informed that she would receive notice once the investigation was closed. So, and the allegations of the complaint do support that. Tenuous as it seems, we submit that her efforts, which aren't unfortunately set forth in the amended complaint, to regain employment with the Treasury Department or with any federal agency may have been impeded by the ongoing investigation under TIGTA or under ECHO, the other investigative agency within the Treasury Department. So for that reason, we don't believe that the statute of limitations would be dispositive of the claims currently pending or currently advanced before the district court and now on appeal before this court. Again, the statute of limitations can be waived. It's apparent that the government deemed it quite a long way to go as far as digging into all the facts concerning discovery of the ongoing investigation and framing that for a 12B motion based on statute of limitations before the district court would have been too cumbersome, and they elected to go straight at the fact that there was not a criminal prosecution, and that's understandable. That's fine. It appears obviously it was efficient, but as far as the state law is accurately recorded by the swearing-in L versus Mick decision of this court, and under state law for malicious prosecution, a civil proceeding can also be the subject of a malicious prosecution claim. So that again, I haven't found the case law that specifically includes an internal agency investigation in the rubric of a civil proceeding. The Judge Johnston concentrated on the absence of a judicial proceeding, but we submit that there is potentially some merit to that. But overall, in responding to the lack of jurisdiction argument made by my opponent from the NTEU, the argument that Lesha Panapinto's conduct in relating confidential information to Jamie Kilmnick and other individual defendants employed by Treasury Department would be stripped away from the 1985-3 subsection 3 jurisprudence, because it's all going to be under the duty of fair representation. We submit that that is not conclusively put forth by the section cited by counsel or by the case law that I've seen. So we do submit that Lesha Panapinto, if no one else from the NTEU union defendants, should be subject to liability, or it should be held to answer an amended complaint or this complaint if the case were remanded for the conspiracy to violate civil rights. If there's no questions.
Thank you very much, Mr. Greco.
Thank you, Judge.
Thank you, Ms. Horn. Thank you, Ms. Mallory. The case will be taken under advisement. We're now going to move to appeal numbers 22-2683 and 22-2688, Artisan and Truckers Casualty Company versus Burlington Insurance. We'll begin with oral argument from Mr. Buck.
Morning.
Good morning.
Tom Buck on behalf of Artisan.
You can move a little close to the microphone. Thank you.
Is this better?
It is. Thank you.
This is a textbook case of a commercial general liability insurance carrier trying to transfer a loss to a transportation liability insurance carrier. The heart of the matter is that we have a truck with a permanently attached crane on it. And it's driven to a job site in Goreville, Illinois, where they're building I believe it's a handy, it's kind of like it's a store, a general store for, and they're installing roof trusses, which are manufactured by Southern Truss. So it designs it and manufactures them, transport it to the site, and at the site, it uses the crane to lift the trusses into position to secure, to build the roof. And Galen Cruz and Mr. Mark Duckworth are on the roof installing the trusses as they're lifted into position. And one of the trusses, as it's being placed into position, falls, knocking other trusses down that had been put into place, and Mr. Cruz and Mr. Duckworth fall and are injured. So,
Does the record reveal the indemnity dollars at issue, what we're talking about in terms of medical bills or anything else?
I understand. I'm not involved in the underlying lawsuit, but I understand that the workers' compensation lien is quite high.
Okay.
Close to one of the policy limits. So there are two policies that are in play here. And they're both for $1 million each, combined single limit coverages. One from Burlington, which is the construction policy, and then one from Artisan, which is an auto policy. So what I would ask the court to consider when it reviews this matter further is to take a look at correspondence, which is in the record as document 1-2. It's attached to Artisan's complaint for declaratory judgment. I don't believe, it's not included in the brief, I apologize. But this is correspondence from Burlington to Dennis Murphy at Southern Truss, denying coverage for the claim. And I point this out because this is the seed of the litigation. This is where it all starts. An insurance company telling its insured, we don't owe you coverage. It has a good explanation of how the occurrence took place, and it cites all of the significant and important policy language from the Burlington policy. And then when it reaches its conclusion, as to why there isn't coverage, it ignores the most operative clause in the policy. That's the exception for the operation of a crane from the use of auto exclusion. It ignores that and simply says, this is the use of an auto, we don't cover you. And this is where the shift begins. It says, if you have an auto liability carrier, contact them. And that's what happens, and that's fine. You know, if I were Mr. Murphy, that's the first thing I would do too. There's nothing wrong with that. But Burlington simply signs off, we regret that we could not be of service in this particular instance. And then it says, you got to understand that we're guided by the language of our policy. Yet it ignores the very language of its policy, which invokes coverage under the commercial general liability policy. Burlington takes this position. Artisan files a complaint for declaratory judgment, and it says, well, wait a minute. We believe that your policy does provide coverage. Burlington takes that position that's stated in this correspondence and carries it on out through the litigation until the district court tells Burlington, you're mistaken, as we thought they were mistaken from the beginning. And the district court has ruled that Burlington owes liability coverage for the use of the crane on the truck. Even though it's on an auto, it owes liability coverage for the use of the crane because the crane is being used to construct that roof. Now, at this point, that's not an issue before this court anymore because Burlington has abandoned that claim, finally abandoned that claim, and has accepted that it owes coverage. But the reason we're here is that Burlington is looking for another way to get around defending the case and to indemnifying the case by relying on an excess clause, by arguing, Artisan, you owe coverage. Our policy is excess. We don't owe any duty to defend, and we don't owe a dime until Artisan pays $1 million.
And Mr. Buck, accelerating to that point, why does the deck page or an Artisan policy include that phrase, including permanently attached equipment?
That's one of the points that the district court cited to, and that Burlington relies upon to try to establish an ambiguity. And what the argument is, the ambiguity argument is that because that phrase is on that deck page, that deck page says that we're providing liability coverage for the crane. That's not what the deck page says. The deck page is referring to that entry for purposes of comprehensive coverage and collision coverage. Because this policy doesn't provide just liability coverage, it provides, well, a lot of coverages that have nothing to do with the accident. And one of those, or two of those, are comprehensive and collision coverage. So if that crane truck is damaged in a collision, and the crane, which is a very valuable piece of equipment, is damaged, that's included in the collision coverage of the policy. It's also included in the comprehensive coverage. So Artisan invites the insured to list what it views as the value of that equipment. So that can be taken into consideration when a property damage claim is adjusted for purposes of the crane. But it doesn't say because you put down that that crane is worth $70,000, you have liability coverage. It doesn't say that at all. But they want to take that and then they want to apply it to an operations exclusion and say, well, the operations exclusion and the liability is ambiguous now because
if
you
we
have
read insurance contracts that way, wouldn't every insurance contract be ambiguous?
That's our position, and it goes also to another argument that's been made that's in a footnote in the court's decision about use exclusions. Basically, what it's saying is because you listed an insured auto on the declarations page, that insured auto is covered for liability. If you have an exclusion in your policy that precludes coverage for certain use of that insured auto, that's ambiguous because you said you were going to cover the auto.
It makes the whole policy ambiguous.
Yeah, it makes 14 exclusions in the Artisan policy ambiguous.
Unless
it makes
they were-
any exclusion in an auto policy ambiguous.
Unless they were attached to every single declaration.
Well, what they're saying is, why didn't you put that exclusion right there on the declarations page? And so I guess what they're asking is that when we write up the declarations page and we list an auto on it, that we include right under there, under the general liability premium, we include all the exclusions there. I guess that's what they're saying.
Every single time.
Every single
For
time.
every single vehicle listed on the declarations page.
Yeah, there are 13 vehicles listed on the policy. Artisan does not write commercial general liability or construction liability policies. Artisan is an auto liability carrier. Artisan does have endorsements for commercial general liability coverage for trucking business use only. But if you want that, you have to buy it. It's a separate endorsement, and that endorsement, first of all, doesn't apply to construction. We don't underwrite construction liability. That's not our business. That's Burlington's business. But if you want the commercial general liability coverage for trucking business, someone falls in your yard at the trucking yard, something like that, you have to buy that endorsement, and then it's attached to the policy that's before the court. But that endorsement was not purchased, and it's not part of the policy. So the other ambiguity which I want to address is, this kind of came out of nowhere. Excuse me, not nowhere. It came out of in a footnote. The court says that, even if we're mistaken about there being a conflict because you listed the truck on the declarations page and then you have the operations exclusion, this is a use arising out of the use of exclusion, and the court has to strictly construe that. And the court would have to find that the operations exclusion itself is ambiguous and unenforceable. No one else argued that, and it's in a footnote, albeit, But sometimes I was always taught that you're not supposed to put anything in footnotes because it's, put it in the main text. But footnotes can speak volumes sometimes, and it can certainly indicate what the author is thinking. Even if you want to take the argument that a use of an auto exclusion is per se ambiguous, there's case law to the contrary, and we've cited that. And Illinois case law is clear that you can have use exclusions in an auto policy. You can have it for carrying passengers for a fee. That's an excluded use. You can have it for using machinery to load the vehicle. That's a recognized exclusion by the Illinois Supreme Court. Or a classic example is an exclusion for a tractor which is not insured for motor carrier use, but is insured for non-trucking use. So it's written such that you do not provide liability coverage for a truck listed on the policy when it's being used in the business of a motor carrier. So there are clearly cases that allow that. And just one more thing, I cite to the Carolina Casualty case versus Burlington, the very company that's here today, where it talks about the operations exclusion in the context of a vehicle with a tank and a pump on it that they use to extract fracking liquid and transport it to sites where it could be disposed of. And Burlington said, yes, but this accident when the truck exploded was caused by the use of an auto. And Carolina Casualty, you cover the use of an auto, and therefore you owe it. And the court said, well, wait a minute, there's an operations exclusion. It says that it does not cover use of equipment attached to the truck. The pump was being used to extract the fumes. This exclusion clearly applies. In fact, it says, it cites to a case that says when there's no duty to defend, when the allegations of a complaint fall squarely within an exclusion, which the 10th Circuit found applied in that pumping truck case. And so, with all due respect to the court below, I don't think that there's any ambiguity in that policy. It clearly states that we do not provide bodily injury liability coverage. We do not provide liability coverage for a bodily injury arising out of the operation of machinery or equipment that is on, attached to, or part of a land vehicle.
Would you like to reserve the remainder of your time?
Yeah, thank you.
Very good. Thank you, Mr. Buck. We'll now move to argument for the appellee, Ms. Tumialan.
Good morning, Your Honor.
Good morning.
May it please the court and counsel. My name is Rosa Toomey Allen, and I represent the Burlington Insurance Company in these cross appeals. Counsel started his remarks to the court this morning by referring to this case as a textbook case of a CGL carrier trying to shift liability to another insurer, the commercial auto policy. This is actually a textbook case of a commercial general liability carrier trying to enforce the intent of what two policies were supposed to dovetail. There was never supposed to be overlapping coverage. There was supposed to be dovetail coverage. This isn't a question about whether there's coverage under both. It's either or, but certainly not concurrent at the same time, which is what the district court concluded. District court found that the Burlington construed that policy to find that the definition of mobile equipment, auto, all those arguments, which TVIC does not challenge here in this cross appeal. TVIC's argument here is limited to strictly the construction of the artisan policy. And what counsel's remarks overlook is that the artisan policy defines insured auto as a term of art. And when I say term of art, I'm referring to Artisan's own description of its policy that it advanced to the Northern District as recently as May of this year in Artisan and Truckers Casualty versus Dollar Tree Stores, Inc., 23 Westlaw 3601734. In that case, Artisan and the court accepted the analysis that the insured auto is the phrase is a term of art defined by the policy to encompass 4 types of vehicles. The insured auto, as defined based on what's described in the declarations page. Then you have an insured auto that is an additional auto, also a defined term in the policy. Then you have a third category, which is a replacement auto, also defined in the policy. And then the fourth category is temporary substitute auto, also defined in the policy. The only at issue here is the definition of insured auto, the vehicle described in the declarations page. So the argument was very discreet. It's very narrow. Because Artisan defined the insured auto to be one category of insured auto to be the auto that's set out in the declarations page, and the declarations term is also a defined term in that policy, then you have to look at what does that say? Well, it describes the auto is listed as the truck with the permanently attached equipment. So now we have one category of insured auto. Nobody disputes that this is an insured auto because it's described in the declarations. So then you look at what is covered under the policy. Well, Artisan wants the court to just go to the operations clause and say, oh, we're out because this insured auto qualifies as a mobile equipment and now it's out. And then but you can't do that without taking away the very coverage that the insured purchased based on definitions that they didn't introduce.
Why? That's where you lose me. I don't understand why. Because when you look at the operations clause, it says bodily injury arising out of the operation of machinery or equipment that is attached to a land vehicle. Why does that not say we cover the vehicle in the event of an accident, but we don't cover bodily injury as a result of the use of the crane?
Well, Judge, because what it says is it's subsection B, which is also an important part, which I will return to that in a second. But to answer your question,
Subsection 13B.
Yes, 13B is what is.
That's what I'm looking at.
Right. Yes. But what I was saying was that there's going to be an important distinction between A and B. But with B, it's the statement is machinery or equipment that is on or attached to or part of a land vehicle that would qualify under the definition of mobile equipment if it were not subject to the compulsory or financial responsibility law where it is licensed or principally garaged. Everyone agrees that this would be subject to the financial compulsory responsibility law. So it's really just a question of is this auto or this truck qualify as mobile equipment? But if you were to find that it did, then that one category of auto, which is described in the policy, and then in the declarations page clearly states that it's the truck plus the permanently attached equipment. No. You've erased the coverage that is being sought there. And I understand that the argument is that, well, then the whole policy is ambiguous. But it's actually not, because this is just one category. There's 4 categories of insured auto under Artisan's policy, which the insured auto is a term of art.
But can you hold on for 1 second? Are you saying that if the crane qualifies as mobile equipment, then the policy is, it doesn't insure anything. Is that your argument?
No.
Because the reason I asked the question is, I find nothing ambiguous about the stated amount. I mean, it's just when I look at it, I see stated amount and I see an asterisk, and it says, a vehicle's stated amount should indicate its current retail value, including any special or permanently attached equipment. And then, when I look at the contract and I look at the limit of liability, it talks about the declaration page, and it says, if the declaration page shows stated amount for the insured vehicle, then the most we'll pay for the loss of your insured auto is at least the least of. And it says, so to me, it seems like the stated amount is just saying the most we're gonna pay for the loss of the vehicle is $70,000, including everything that's attached to the vehicle. But why does that make the operations clause ambiguous?
The operations clause is not ambiguous. That's not the argument. The argument is that the declarations page, because of the way that insured auto is defined, it creates an ambiguity in the application of the policy because one of
In what application of the policy specifically?
When you, if you were to take the declarations page at its face value, as the insured did when they purchased the policy, they have a declarations page that says, here's your truck, it's insured, your insured auto. Here is the truck and including the permanently attached equipment. Taking that on its face value on the deck sheet that Artisan prepared, the insured reasonably reads that, and I think is a reasonable reading to say, okay, I'm insured for liability arising out of my
But then how
training.
do they read the operations exclusion? That's the question. Like, what specific provision is ambiguous due to the declaration page? What specific coverage provision should I look to?
The definition of insured auto, Judge, and that would be, if you look at.
I see it right here.
Yes.
Yeah, 2,
So,
right?
well,
Definition.
That's auto.
Right.
And then you go to number 5 is insured
Insured auto.
auto. Any auto specifically listed on the declarations page.
Right,
And
no
then
problem.
declarations page has its own definition, and it means the document prepared by us, which is Artisan, listing your policy, so that's Southern Trust, information, which may include the types of coverage you have elected, the limit for each coverage, the cost of each coverage, the specifically described auto covered by this policy. The specifically described auto covered by this policy on the deck sheet is the truck plus the permanently attached equipment.
No doubt. There's no doubt about that. But how do you deal with the operations exclusion?
Well, that's the problem, because for this one category, and again, there's 4 categories of insured autos in the policy. One category, when you include the permanently attached equipment in the deck sheet, and then you take the coverage away from the operations clause, that creates the inherent ambiguity, inherent inconsistency that is intractable, because the coverage that is given by the definition of insured auto when it's qualifying as an insured auto because of the declarations listing is taken away.
Isn't that the whole reason for an operations exclusion? I mean, isn't that, like, I look at these definitions, they seem very standard and easy to read. Auto, declarations page, insured auto. You follow right along in the definitions, and you look at the declaration page, and it states the value of the auto, should the insurance coverage apply, and then you look at the operations exclusion, and it says we don't cover bodily injury, property damage, covered pollution, cost, or expense arising out of the operation of the machinery or equipment. And I don't think that, at least maybe I'm wrong, is it Burlington's argument that the truck doesn't qualify as mobile equipment?
We don't even have to get there, and nobody's gotten there, because the argument
That's
was.
what I thought too.
Yeah,
But you
okay.
made that argument. I had
Right.
a little question here. But maybe I thought you were arguing mobile equipment, which I didn't understand it.
No.
That's why I was asking.
No, the argument is, again, very discreet, very limited to the definitions that Artisan chose to draft the way it drafted when it drafted.
But what's
the policy.
ambiguous about the definition? Like, what specifically, what word is ambiguous?
So it's ambiguous in its application, because if you have 4
Application,
categories.
what provision, what application provision is ambiguous?
The definition of insured auto, when that auto qualifies as insured auto because it's listed in the declarations page. And when the
But how is
declarations
that
listing.
ambiguous? I mean, it just says any auto specifically described on the declaration page. So any auto specifically described on the declaration page is covered. They're not arguing that it's not. They're arguing if there was an accident, if they were driving the truck to a work site and there was an accident, that truck and crane are covered up to $70,000.
So the ambiguity is the inconsistency within the policy. When you specifically list the equipment, you list the policy. The policy says your insured auto on the declarations page.
How could
The
it have been?
specifically described auto is covered by this policy. That's a specifically
How
described
could
auto.
they have fixed it? What would have made it not, like, if you were writing this contract, what would make it unambiguous?
Not defining insured auto to be the way that they've defined it. Because now
So
you have
not have a declarations page?
no, you can have a declarations page, but they've chosen to define insured auto this way. There's all kinds of different ways they could have done it, and
Like, name
but they
one.
did it. Well, they
Give
didn't
me-
have to define. They didn't have to define insured auto as the one specifically described in the declarations page, or they could have said in the declarations page the auto, but not the permanently attached equipment.
When you're looking at insured auto is just a definition clause. Where does this apply? If you get to the coverage provision, where does insured auto, where does the definition of assured auto make a difference in your argument?
Well, it makes a difference in the entire argument, because we can't ignore insured auto. It's woven throughout the policy. It's the assumption under which all coverage is based. You have to look at the four categories and see which one applies. In the Dollar Tree case that Artisan argued to the Northern District, and the Northern District accepted, that case went through the analysis of all four different types, and then agreed with Artisan that the car in that case did not qualify as an insured auto, and then granted their motion for summary judgment on the duty to defend. But you can't have it both ways. If you're going to rely on your language that you drafted to not have a duty to defend, then that same language has to apply evenly and equally. And here, there's an ambiguity because it's inherently inconsistent to specifically insure the auto and the permanently attached equipment as one category of insured automobile, and then exclude it by the operations clause. Very quickly, Your Honor, with respect to the mobile equipment definition, we did not get there because Artisan, the entire argument was about inconsistency and internal inconsistency in the policy. But if the court were to disagree with TDIC that there is no ambiguity, then the case needs to be remanded, because there needs to be an analysis of whether or not this crane truck equipment qualifies as mobile equipment, which would require application and construction of that policy language, which was not done. And then Artisan bears the burden of has to be clear and clearly applicable exclusion to these facts, and they have not done that. That's a burden that they have not reached. And I see I'm out of time. We would ask that the district court's ruling with respect to Artisan be affirmed, but that the district court's finding as to TDIC status as excess be reversed, and the TDIC be found not to have a duty to defend, but only indemnify as an excess carrier.
Thank you very much, Ms. Tumialan.
Thank you.
We'll next move to Mr. Watkins.
Thank you, Your Honor. May it please the court. I've only got 2 minutes, so I'm going to be brief. There's a couple things I want to address based on the arguments that have been had so far. First, as to the use exclusion and the judges at the trial court's level addressing that as another basis for finding the exclusion not applicable and finding that Artisan does have coverage. Myself, on behalf of the appellees, cross appellees, Mr. Duckworth and Mr. Cruz, did argue that that use exclusion was ambiguous. We argued that, and I apologize, it's not noted in our brief on this, our joint brief with Southern Trust and Douglas Forest, but it's argued at document 63 at page 6, and specifically with reference to the Penn Star Insurance Company v. Zenith Insurance Company case, which is 436 F sub 3rd 1367. And the import of that case is real simple, is what you have to deal with, what the average person, which is what we're looking at here, has to deal with in order to understand these policies, is they have to jump around between the definitions, between the exclusions, between the declaration page to find what their policy actually means. And when you start looking at the verbiage that's used, and frankly the definitional and exclusion gymnastics that an average person would have to go through. When lawyers and judges have difficulty with these provisions, how can you expect the average person to understand them when they're referencing financial responsibility laws and insurance laws that they don't know what to look for, they don't know where to look at in order to determine what exactly they're intended to define. Very briefly, since I have very limited time left, in terms of what the artisan could have done to make their exclusion explicit, clear, and definite, they could have added a double asterisk next to the stated amount of the
Well, they could have restated the entire contract after every single list, right? They could do that. I mean, we get to the world of the absurd, though, right?
May I respond since
Yes.
I'm out of time? Thank you, Judge.
Oh, yeah.
So what I would say to that is, yes, the argument that, you would have to restate every single exclusion under, I don't think that applies, because most of the use exclusions are generally meant for the entire vehicle, the use of the entire vehicle, which is what we're dealing with here, the use of this entire vehicle, which is listed as the truck and the crane. The use exclusion they're trying to use here is specific to the crane that's listed here. So if you had added just that use exclusion with reference to the crane, the permanently attached equipment, which is the only place where that issue comes up in the use exclusions, we wouldn't have this problem.
Thank you very much, Mr. Watkins. Mr. Buck, we'll go back to you for rebuttal argument.
Thank you. Just briefly, counsel raised the ambiguity argument that was argued below that wasn't raised in the briefs here. And that aside, there was a response to that, and I'd incorporate by reference our response to that argument from below. If anyone has any questions about the Artisan versus Dollar case, ask away. I was involved in that case. That case involved a truck that wasn't specifically listed on the policy and didn't qualify as to the other three categories, which was why the other three categories were addressed in that decision. This case, everybody admits that the truck is on the policy. So the issues raised in that Dollar case are really separate and apart from this case.
Is the insured auto definition ISO language?
Pardon?
Is the insured auto definition ISO language coming from the Insurance Service Organization?
You know what? Progressive does not use ISO language, but the operations exclusion and the Burlington policy does use ISO policy forms. And the language that's used to accept the use of the crane as a use of an auto from that exclusion in the Burlington policy is ISO language. And that's the same policy and language that Progressive uses to exclude it. So I don't know if this is mirroring, if that's the correct term, but when it comes to the phrase equipment attached to, permanently attached to the vehicle, Artisan cites to that language as an exclusion. We don't cover bodily injury arising out of the use of the equipment. Yet Burlington uses that language as an exception to its use of an auto exclusion. So the Burlington policy does cover the bodily injury arising out of the use of the crane. That's where the two policies dovetail. So to answer your question, the Burlington policy is an ISO form, and risking any chance of putting my client in jeopardy, it's not an ISO form, but it's the same language. I don't want to get Progressive in trouble with ISO.
Thank you very much, Mr. Buck. Thank you, Ms. Toomey Allen. Thank you, Mr. Watkins. The case will be taken under advisement. We are now going to move to appeal 22-2944. This is Laura Mullen versus Ricky Butler. And we're going to begin with oral argument for the appellant. Ms. D'Ambrose, will go to you first.
May it please the court. Morning, Your Honors. My name is Danielle D'Ambrose, and I represent the appellant defendants Rick Butler, Cheryl Butler, and GLB Inc. The case before this court involves the review of 3 district court decisions that are all related to sanctions. First is the district court's flawed analysis in its order sanctioning the defendants and their counsel. Second is the district court's misapplication of controlling law when it punished the defendants with court fines and attorney's fees. And third is the district court's failure to consider several well-supported and viable arguments in their motion to sanction plaintiff and their attorneys. Almost exactly 2 years ago, this case was before this court after the plaintiff appealed the district court decision that granted summary judgment, which disposed of the plaintiff's claims. Laura Mullen, the plaintiff in this action, is a mother of two daughters who played in defendants' programs between 2012 and 2017. She alleged in her complaint that the defendants fraudulently concealed claims of sexual abuse that were made against Rick Butler that dated back to the 1980s. These allegations were first made public in 1995 and have been pretty heavily reported on in various public discourse since 1995. Specifically in 2015, it was in ESPN's Outside the Lines, as well as several other articles related to either ESPN or other news sources reporting on what ESPN.
What difference does that make? What difference does that make?
Laura Mullen filed a lawsuit claiming that the
I know she did, and she made these allegations in the lawsuit that were, at least in some part, true.
As far as the fraud claims?
As far as some of the things that you don't like, use of the term rape and things like that in the complaint, this happens all the time, every day in civil litigation. It does not amount to Rule 11 sanctions.
Well, the Rule 11 sanctions stem from the fact that Laura Mullen filed this case claiming she saw nothing about this online until June of 2017, until after her daughters left the program. She claimed she was duped, that she was defrauded by the defendant. She would have never allowed her daughters to play for the defendant's program if she had known about these allegations at all. She claimed that she didn't see anything online until June of 2017, when in reality she was actively discussing these in 2015, 2016 while her daughters were in the program. She repeatedly was signing her daughters up while having full knowledge of what she was claiming was being concealed from her. So the allegations of fraud fail, and they failed from the very beginning. And she knew what she was claiming that was hidden and concealed from her. So this case on summary judgment, that was what the court found, that it was Mullen's case was foreclosed on summary judgment, and then the class claims were dismissed because there was no representative that could take the place of Mullen. Mullen was the class representative claiming to represent the interest of thousands of individuals. The class notice process, I think, involved notice of about 2,000 people who had children that played for Butler's programs. After class notice went out to 2,000 people, there was not anyone that was identified that could either take Mullen's place or even in discovery. We requested information about who supported her case. Did she have any witnesses? Her attorneys were in the media saying that they were getting calls left and right from people. Yet when asked about it in discovery, no answers were provided. We still have not been told that there was anyone that she knows of that can support her case, which is specifically notable because she also spent years in this program, and that sort of raises the issues within the court's rulings for sanctions as well. That the courts, there was kind of 2 different court cases going on here. There was the case that was happening in front of the court, and then there was the reality of what it looked like at kind of the ground level here. And we were forced to live in this reality when we were in the court system that it appeared as though, its class members were, it's not a normal class action, I guess I would kind of explain it like that, where we have customers who have some distance between the people who are behind the curtain, the company that they're suing, the people who defrauded them. Here we have class members who have known about these allegations since they joined the club. Their kids played for the Butlers. They travel with the Butlers. They have practice every day, just about. They go out of town several weekends a year, if not more, with the coaches in the GLV program. And these allegations are a hot topic in the volleyball community. They are very well known. Yet Mullen filed this lawsuit claiming that none of these class members knew anything about these allegations.
Does the record reveal any timing between when something might have had to be shown on the Butler website versus when the Mullins signed up?
I'm sorry, can you?
Sure. So at some point there was some disclaimer that had to be placed in anything that the Butlers put out about the prior circumstances.
Are you saying that's what Mullen was alleging, is that she wanted there to be some disclaimer?
Right. Where that juxtaposed time-wise with when the Mullins signed up.
So Mullen just alleged in her complaint that her claim was that there was some broad duty for the butlers to disclose this, but there wasn't. That's just Mullen's claim, that there was a duty to disclose this. There was nothing that required the butlers to put anything out there. There's a lot of politics, other issues involved with the USAV. He was banned for a protective order violation, and it kind of Mullen and her attorneys and others that were the accusers sort of tried to spin that to make it appear as though it was for other reasons. But there was no. I think that maybe what you're referring to, the USAV proceedings and findings, and that was never a requirement for the butlers to disclose anything. USAV actually, butlers weren't even a member of USAV. The program wasn't a member of USAV. So when USAV was claiming to be protecting their athletes, there was no athletes that were playing for sports performance that were members of USAV. USAV was there are other, again, issues at play with Rick's involvement in creating a competitor to USAV that impacted, I believe, that decision to ban him based on allegations from the 1980s that were largely adjudicated back in 1995 when the USAV originally did hear these allegations.
Question concerning the sanctions against you, jurisdictional question. What is your argument that the notice of appeal, docket entry 235, included the allegations personally against you?
So the notice of appeal it's the appeal of the court orders that specifically sanction plaintiff or defendants and their attorney. Mm-hmm. And specifically when we get to the fee petition, that's where this kind of really comes to fruition, is where originally the court's ruling on the motion for sanctions kind of parsed out the difference between what the defendant's conduct was and what my conduct was. Then we get to the fee petition, and that was the difference between those two kind of evaporated. And instead, there was a lot of allegations of or findings that my clients were being held responsible for fees of misconduct that was supposedly done at the assistance of it was the defendants and their counsel, was the court's verbiage, and it was used several times throughout. Yet there's no specific findings of any actual coercion of class members, no actual findings of any misstatements that were made or any actual class member that was misled. There was this focus on a potential for coercion that the court said arose purely based on the nature of the relationship of the parties, which, again, that sort of comes back to that there's two cases going on, the practical implications of saying that there were class members who could be coerced to opting out of the case because they wanted to stay in the good graces of the defendants. Can't make sense with the fact that those people, if they want to stay in the case, then must believe that Rick Butler is a danger to the players he coaches and that the program should be shut down. So to be subject to being coerced because you want to be in the Butler's good graces can't live with the same reality of also believing the claims that Mullen was putting forth. And I think importantly is looking at the actual text of the conversations themselves. These aren't wishy-washy, class members who were looking for information about the allegations. They made it very clear that they were not having what was being put out in the lawsuit. They said, I want to opt out. I have no interest in this. I resent being dragged into this litigation. I know Laura Mullen is lying. I will provide testimony for you. Those are the responses those are the emails that the Butlers were responding to. I think part of the appeal is that the defendants can't be held responsible for coercing opt-outs that were already decided on when they were being contacted. The communications at issue by the Butlers happened after they were contacted by these class members. And with that, I'm sorry, I would like to hold the remainder of my time for rebuttal.
Very good. Thank you, Ms. Dambrose.
Thank you.
We're now going to move Mr. Chevsky to you for argument from the appellee.
Morning, may it please the court. I would submit to the court that there is one case and one reality here. And in that reality, the district court sanctioned the defendants because they willfully interfered with the class notice process by running a misleading and coercive opt-out campaign. Judge Kennelly warned the defendants at the start of this case, before class was even certified, that misleading communications to class members weren't acceptable. That's at docket 73 during a hearing. And by the time class notice went out here, defendants had already made clear by their actions that they had a goal to maximize the number of opt-outs. They asked Judge Kennelly to permit opt-outs by email, which he declined to do, citing some of the problems with communications that had happened earlier in the case. And they also asked for an opt-out form to be included with the notice separately, and Judge Kennelly also declined to do that. So when a Facebook page materialized, the same time class notice went out, that solicited opt-outs and had an opt-out form on it, we thought it suspicious, and we brought it to the district court's attention. We did not file a sanctions motion at that time. We just filed a notice. We said, this is happening, Your Honor. You should probably know about it. And if at the resulting hearing that Judge Kennelly called, the defendants and their counsel had been honest about what they knew and what they'd been doing, what they'd been saying, I don't think we'd be here. But when Judge Kennelly asked Ms. D'Ambrose what defendants had been saying to class members, she made a material misrepresentation of fact. And then she didn't correct the record. And so that's why it fell on my client and us as class counsel to investigate what happened, prove that the statement hadn't been true, and bring the results back to the district court. If the defendants had been candid about what happened, that all of that time wouldn't have been necessary. It wouldn't have made the communications proper. And in fact, I heard some argument that perhaps the communications weren't improper. They conceded below that the communications that the Butlers and GLV had with class members were not appropriate. That's counsel's words. And so that point's waived on appeal. And so it wouldn't have made the communications more proper, but it would have made an attorney's fee sanction unnecessary. As it stands, the district court's conclusion is reasonable. The communications were both misleading and coercive. I will note that they were not all in response to inquiries. There was a preemptive email sent by GLV, one of their executives to one of the volleyball programs about it. So that certainly wasn't in response to specific inquiries. And the district court's conclusion is reasonable, that the notice that the interference was willful and the sanctions were warranted. Turning to the denial of the defendant's sanctions motion, again, there's no reason to reverse here. The district court recognized that our legal theory wasn't successful. Sometimes we lose cases. That doesn't make it sanctionable. There's a wide gap between a legal theory that's not successful and Rule 11 sanctions. I heard repeated references to allegations that Ms. Mullins saw nothing at all, and that's not in the complaint. The allegation in the complaint is that she did not know the extent of what had, the extent of the allegations and the truth of them. I think what counsel is referring to is a secondary argument in response to a judicial notice request made in a footnote in a response to a motion to dismiss. I don't think that amounts to an allegation that my client saw nothing at all. Certainly that's not what the district court based its decision on. And I think the district court explained that very clearly and in probably more detail than it was required to in order to deny a sanctions motion in its written order. And where you've got a district court that's provided a detailed and reasonable explanation of why it has used its discretion not to grant sanctions on appeal, that's really the end of it. And so because there's been no error here, we'd respectfully request that the court affirm the district court's order in full, except for the portion over which there is not jurisdiction. I can address that if the
Please.
court would like. So I guess I'm slightly confused, but I will try to make sense of it. Originally in the questions presented, one of the questions was, was the sanction against defendant's counsel appropriate? As far as I can tell, that hasn't been appealed. Ms. D'Ambrose would have had to put herself in the notice of appeal for there to be jurisdiction, and she simply didn't do that. As far as whether what she was sanctioned for is something that the defendants ended up paying for. I don't think that's quite the case. So the sanctions against Ms. D'Ambrose were for making a misrepresentation of the district court and communicating with a represented party. Those are the sanctions against her. I don't think there's any indication that the defendants ended up paying for either of those things. Now, there are some things that Ms. D'Ambrose did that defendants ultimately are held responsible for because parties are stuck with what their counsel does. And so, things like making a misstatement and not correcting the record, requiring a further investigation, that is conduct that is ultimately on the defendant. But it is not the professional responsibility consequence of making a misrepresentation to the court that they're being sanctioned for. It's what happened because their counsel did that and they're stuck with what their counsel did. And so, I guess to the extent that there is some question as to whether Judge Kennelly's view that this was a misrepresentation is relevant to this, and I don't really even think that's been raised, perhaps that would come into the defendant's appeal. But to the question of, did Ms. D'Ambrose fulfill her professional obligations to the court, or was the sanction against her appropriate, I don't think there's jurisdiction for the court to review that. So with the except...
And I'm not saying it's dispositive. The docket entry 235 references 4 orders by Judge Kennelly. One of them is docket entry 184, a March 13th, 2020 memorandum and order with the sanctions against Ms. D'Ambrose. It's a CMECF link. I don't know that it's dispositive or not, but I wanted to mention that for the record just in case you had any commentary on it.
I think, when you're looking at notices of appeal, it's a little bit more of a holistic analysis, I guess. And I think when you look at that notice of appeal in its entirety, it is clear to me on its face that it is the defendants who are appealing and not Ms. D'Ambrose. And that's really the jurisdictional question here, is who appealed, not what did they appeal. And so it looks to me here as though the defendants are the ones who appealed, and they did so on time, but that Ms. D'Ambrose didn't do so. And a defendant, or a party, can't appeal on behalf of their lawyer. Unless the court has any other questions, I'm happy to proceed.
Thank you very much, Mr. Tiefsky.
Thank you.
Ms. D'Ambrose, we're going to go back to you now for rebuttal argument.
Thank you, Your Honors. To be clear, plaintiff first argued that in response to defendant's motion to dismiss, that argued that Mullen's claims of being deceived were not true, that she had referenced an ESPN article in her complaint where she claims that the Butlers concealed these allegations of abuse from the 1980s. She claims she did not see anything, that the class members were all duped, that they had no way of knowing this information because the Butlers had to disclose it. In response to defendant's motion to dismiss, plaintiff argued that judicial notice was improper of that ESPN article that was cited in Mullen's complaint. In quote was, because none of the articles are referenced in the complaint and they're inconsistent with Mullen's claims that she did not see any information online until June of 2017 due to defendant's concealment. That is what she argued, and that is what the court relied upon, in part at least, in denying the defendant's motion to dismiss. If we had known that Mullen the concealment claim was crucial to getting the class certified in this case as well. That was the uniform act that the court based class certification on, where in arguing against class certification, the defendants submitted to the court nearly 700 pages of documents that had class members who were engaged in similar sort of activities where they rallied around the Butlers in light of the same allegations and the same attacks from the same individuals beginning back to 2015. In 2015, there was this campaign, they called it Spry or Die, and it was, Spry is the shorthand version of sports performance, and these class members, in response to the ESPN articles and the attacks on the Butlers, started this social media campaign where they were posting positive testimonials and again rallying around the Butlers in light of these exact same allegations that Mullen claims were concealed from these class members. Then in 2017, the AAU was conducting a review of Butler's membership, and the class members again email campaign they started. They had again rallied together. They were all emailing each other behind the scenes, very similarly to what happened in this case. So when the court looked at the defendants and said, well, I could understand why there would be some curiosity or maybe at first view maybe an assumption that the defendants were somehow involved. However, in light of what was actually presented to the court, in the evidence or the lack of evidence that ended up coming out in the end after discovery on these issues, it's clear that the defendants weren't involved. They were not responsible for the Facebook page. They were not responsible for the email campaign. There's nothing that the defendant or that the plaintiff or that the court has been able to point to show that the defendants actually had any coercive impact on opt-outs. These class members, again, they were informed. They had already participated in at least 2 very similar campaigns in recent years, right, shortly before the class action was filed. So again, while the defendants weren't behind it, the defendants weren't surprised that this sort of act happened and tried to indeed warn the court that certifying the class would raise these sort of issues. And with respect to the sanctions against me, which that's not really the focus of this appeal. The appeal is related to the fee petition that my clients that was imposed on my clients and the motion for sanctions that was denied. However, it does speak to the motion for sanctions being denied that the court didn't really address the continued allegations that both the defendants and myself were engaged in misrepresentations for the purpose of soliciting opt-outs or for the purpose of tricking people into opting out of this class action. There's been no actual evidence of that. In addition, the plaintiff...
I didn't see anywhere where the district judge said that you were tricking people into opting out.
Misleading. It was the plaintiffs that repeatedly alleged that...
They were coaching them to opt out, not tricking. There was no trickery in these text messages that says opt out, !
So there was no, I would just argue that there's no coercion in those either. The class members had contacted, especially in the text messages and emails, with pretty clear intentions of opting out and pretty clear opinions that they already had about the lawsuit before the Butlers even responded. And with respect to the misstatement that I made to the court about the email that went out from Troy. First, that email that went out from Troy was in response, and Troy submitted a declaration that said it was in response to getting calls. He's the boys program coordinator. The boys program, he was being approached because people in the boys program were understandably confused. They didn't think that they were part of the class action. They were getting this notice and thought this wasn't intended for me. And he had to then have these individual talks with people. So he said that instead of having individual discussions, he would send out a neutral, unbiased, just factual email that said, check your spam folders, this does apply to you. And again, if looking at the text of the actual conversation that he had, or the actual email that he had sent out, there is no misstatements, no coercion. And with that, I see I'm out of time. Thank you.
Thank you, Ms. Dambrose. Thank you, Mr. Tiefsky. The case will be taken under advisement. I'm going to let the clerk's office know we're going to take a brief break at this point. We'll be back on the record in a few minutes. We'll move next to appeals 23-1527 and 23-2566, UIRC GSA Holdings versus Blair Company and Cult. We'll begin with oral argument from Mr. Schultz.
Thank you very much, Your Honor. May it please the court. This is a lot of issues addressed in the briefs, but I'm going to try and confine my focus today to sort of the heart of the case. And at its heart, this is a copyright case, and it's kind of an unusual copyright case. It's unusual in the sense that the legal issues it presents are somewhat different than the legal issues that come up in most of the copyright cases that this court sees. And part of the reason for that is that the investment itself that's at the heart of this case is an unusual investment. And I think it's worth making sure everybody's on the same page about why that is and how it works. So UIRC's business is basically to acquire and manage properties leased to the federal government, the GSA. And there are some unusual risks attendant to that business model. The government obviously is not your standard tenant, and they are driven by different motives than other private investors. The government also typically insists on short-term leases. So you don't have a 10 or 12-year lease where at least you're locked in and you can plan. And the government frequently takes the whole building. So now you've got a real combination of risks that are attendant to this business model, and a lot of people aren't comfortable with those risks, and so they stay away. UIRC then, in trying to raise money, added yet an additional complication by saying what we're going to try and do is go into the bond market and raise enough money that we can buy a package of these properties, 10, 12, a dozen of them. So now you've added yet another group of risks to your plate, in the sense that you now have 12 of these risky properties that people are wondering about. So UIRC, looking at this, essentially had a decision to make. Can we get into the bond market and convince sophisticated investors, because the money we're talking about, we're going to need to go after sophisticated investors to put money into this. And essentially they said, we're going to give it a shot. And so to do that, they knew essentially they had to present this investment opportunity in a way to satisfy two pretty sophisticated groups of people. First of all, the bond rating agencies who would look at this and give it a bond rating. And then secondly, the investors themselves, who were going to have to decide whether to put their money into this deal. To do that, they had to present the investment to the community in a way that got people to put a lot of money on the table and give them a lot of money. In doing so, there's two basic documents they had to draft, two basic documents that come into play. One is what we call the CPM, PPM prospectus, the sales document that basically the investors get. And then there's the indenture of trust, which is the legal document, the roadmap that spells out, okay, this is where everybody's rights and obligations and responsibilities are. And the two have to work together. They do work together, because if they don't work together carefully, you got a securities law problem. So you have to sort of tie the two of them together. So UIRC went and decided to try and do this. They did get this Idaho bond document to start at the beginning of the process. But it's important to understand that transaction, while it was a bond transaction, was very, very different than what we're talking about. That was a deal to build a research facility and labs at Idaho State University. So from the perspective of the bond buyers, very, very different transaction, different set of risks, different set of incentives, different money flow, all of those kinds of things. So while yes, there are, in any bond transaction, there are a lot of what we lawyers might call boilerplate provisions that are common to pretty much any transaction. You also had here the heart of the deal, which is UIRC had to find a way to draft these key provisions addressing the key risks in a way that would convince the bond agencies to rate the bonds properly, and then bond buyers to buy them. And so that's what it did. And it drafted these provisions. What are the provisions that mainly are important? Well, there are two, sort of. There are two kinds of provisions. First, there are the provisions that talk about the risks, that talk about how we're going to deal with the risks of this. There's repositioning procedure provisions, there's extraordinary redemption provisions, and essentially what those talk about is, okay, so what does happen if we give you this money for 12 properties and it turns out 2 of the deals fall through and you've only got 10 properties instead of 12? Or what happens if you get all these 12 and a year after we get into this, the government decides to move all its operations from this one building to Alexandria, Virginia, and all of a sudden now we got an empty building in our portfolio. And so there are provisions to deal with those risks. And then the second important one, and this is the one we put in the appendix to the brief, of course, is, you know, what we might call the application of revenues or the waterfall provisions. Follow the money. You know, that's obviously always central to every bondholder, is where's the money going to come in and where does it go once it comes in and how is it going to be managed, and 1,000 questions about how all that works. So UIRC did just that. Drafted those provisions, those key provisions, essentially from scratch. And it did use boilerplate for a lot of the stuff that nobody reads, quite frankly, in the end, okay? It did that, still couldn't get Moody's or Fitch or S&P to rate the bonds. These were still unusual enough that those agencies wouldn't touch them. But they were able to get the NAIC to give it what they call a shadow rating so that insurance companies could buy them. And then they went out and sold these bonds successfully and went through 4 different versions of this essential same transaction where they got groups of properties using this process. The second one was a little different because they got off track a little bit and it didn't work as well. So with the third and the fourth, they went back to their original model. Third and the fourth is where they brought Blair in to work with them. And the transactions were successful. There's no question about it. They sold the bonds. Blair did a fine job as the placement agent. There's no dispute about that. Got the buyers in. And then what happens is that while they're working on UIRC 5, the 5th set of these transactions, the Blair folks say to themselves, hey, UIRC's onto something here. We can make some money on this. What we need to do is go out and find somebody else who's willing to take this model, and we'll take UIRC's documents and use them to help somebody else do these kinds of deals and make all this money. And that's essentially what they did. Exactly what they did is they took UIRC's copyrighted PPMs and their indenture of trust, and they sat down and essentially copied them. And yes, a lot of the stuff they copied was boilerplate stuff that we don't care about and that we don't claim a copyright over. But a lot of the stuff that they copyrighted was the heart of the documents, the essence of the documents, these repositioning procedure documents, the special redemption, and the waterfall documents that were really the essence of what, at least in our view, and I think the evidence backs us up on this, made this a successful transaction. So that's why I say, in this sense, this is kind of an unusual copyright case, because most of the copyright cases, like, for example, the design basics cases that have been in front of this court, the last 3, I think, copyright cases, turn on to more typical issues of access and copying and, you know, is there access? Well, we don't even know if there's access. We can't prove there was access. And therefore, it's hard to be sure about the copying part because we don't even know if they saw this particular thing. There's no dispute about any of that here, at least, you know, certainly for purposes of summary judgment. Yes, they might quibble a little bit on a bit of this, but on summary judgment, there's just no dispute that they had our documents, that they copied our documents, and that they used our documents to help Rainier engage in pretty much the same transaction. So the question simply then is, from a copyright perspective, should they be able to get away with that? Judge Gettleman's answer was, we find it a little short, because it basically boils down to the one sentence where he says, well, the problem is that your copyright, even if we focus on what you call the heart of it, or what he called, I forget the exact terminology he used, but the heart of the documents, there's unprotectable facts, fragmented phrases, functional phrases akin to instructions, and subjects that can only be expressed in certain words. And our response to that is, at least initially, well, if you're going to start breaking down page after page of text, and the text that we're talking about here, at least the essence of it, goes on for 6, 7, 8, 9 pages, if you're going to start trying to break that down into individual facts, individual phrases, then copyright law is going to disappear, because you could do that for War and Peace, you could do that for pretty much anything, if you try to break things down like that. And in the Bucklew case, I think this court said pretty clearly that's just not something that works in the copyright sense. The other two things that Judge Gettleman pointed to, and again, he did all this without really tying his comments to any specific language in any of the documents. He just sort of threw it all into a big bushel basket and said it's all part of this. Functional phrases akin to instructions and subjects that can be expressed only in certain ways. The certain ways one, it's interesting to think about, because the evidence on that is just squarely the opposite. There is really no dispute that you could do this other ways. It is a logical matter. There is no reason to think that somebody couldn't sit down and write a description of an investment in a bunch of GSA properties and write it in a completely different way than UIRC wrote it. There's a logical matter, no reason why somebody couldn't do that. The experts, both experts, our expert and their expert, agree with just that there's no reason that somebody couldn't have sat down and did just what we did, and write it up a different way using different language, etc., etc. And then third, it was done. In UIRC's second transaction, the one I alluded to a minute ago, UIRC sort of, I say kind of got off track, but they just sort of, they still hadn't kind of figured out the formula yet, so they went in a little bit of a different direction with the documents, and it didn't work. But they were able to go in a different direction, it just didn't work. And then Rainier, after they discovered the problem, because at the end of the day, what came out is that Rainier had no idea that Blair had taken our language to draft Rainier's documents. So Rainier said, well, okay, let's try and do one of these without using UIRC's language. And they did. They tried to do without either Blair or our language. They tried to do another deal, coming up with different language, using their own language. That transaction didn't work. But the point here is simply that there's no dispute, there shouldn't be any dispute, that this is something where they could come up with their own language if they wanted to, that other people can come up with their own language. We are not saying anything other than, we're not trying to say that nobody else can do a deal like this. This isn't like a patent case where you might say, hey, we have a patent over this, you can't manufacture this item, or at least you can't manufacture and sell it because our patent gives us the right to keep you from doing that. We're not trying to take the position that nobody else can go out and do what we did and bring a deal like our deal to the market. You just can't use our words to present it to the market. That's basically what the copyright laws are about, is the idea, and that's the heart of what we're saying here, is that the real problem here was that they used our words to present their deal to the market, and that's the essence of our claim. So with the court's permission, I'll save the rest of my time for rebuttal.
Very good. Thank you, Mr. Schultz. We'll now move Ms. Henning to you. Argument on behalf of the appellee.
Morning, Your Honors. May it please
Morning.
the court. We do agree about one thing, that a copyright suit over bond documents is unusual. We disagree a little bit about why it's unusual, but we agree it's unusual. But I will say, the case went from unusual to frankly a bit flabbergasting when William Blair learned through discovery sent to a third-party law firm that UIRC itself copied most of the language over which it was claiming copyright from a third party and did not have permission to do so. After being confronted with that fact, UIRC attempted to, in the course of summary judgment briefing, change the scope of its copyright claims to only those portions that were edited. In other words, only their edits over those other documents. But that can't carry the day for UIRC for at least two reasons, or both. One is that at best, even if you accept many of the premises of UIRC's arguments, that would create a derivative work that it did not have permission to use and thus would not be copyrightable. But second, and as Judge Gettleman ruled, it also, the edits are not original enough to warrant copyright protection. I'd like to start with the argument on derivative work because that was addressed in the reply brief. So I'd like to respond to a couple of arguments made in the reply brief. Essentially, UIRC is trying to press an argument here that was expressly rejected in this court's Pickett case, which is, I'm not trying to copyright the copyrighted thing. I'm trying to copyright my changes to the copyrighted thing, and those are original and those are different. Pickett directly rejected that argument, and it explained why. It explained why because if you're trying to talk about alterations to the original, you're going to create all kinds of problems for courts because it's going to be very hard to know who had the first one. You're going to have alterers suing alterers and claiming that they were the first to get there, and it's the act is designed so that only the original copyright holder is the one who can control subsequent use of that work, and it just makes it much easier for courts and society, frankly. UIRC says, no, that's not the case. If you look at the Schrock case, that shows you otherwise. The Schrock case, first of all, cites Pickett and does not purport to overrule it. So it absolutely does not even portend to overrule Pickett. But more to the point, Schrock is deciding a different issue. In Schrock, what happened was a photographer photographed a Thomas the Train engine, which is a copyrighted image, and eventually the people who make Thomas the Train, who gave that photographer permission to make those photographs, for a while they had a great relationship. The Thomas the Train people were paying the photographer to use that work in their marketing. They eventually reached an impasse, and the photographer wanted to continue using his work, and the Thomas the Train people said, no, it's a derivative work, and you don't have our permission to use the copyright. And what this court said was, when you gave the photographer permission to photograph the train, you implicitly, unless you agreed by contract otherwise, gave him the copyright to that derivative work. That's a totally different issue than what we're talking about here. No one's contending that anyone from Idaho gave UIRC permission to use this language. So Schrock doesn't help. The only other argument UIRC really has on this derivative issue is to say that essentially the argument would need to presume that the Idaho language is copyrightable. That argument can't succeed for a few reasons. First and foremost in my mind is that the edits to the Idaho documents can't be more original than the documents themselves. In other words, if the Idaho documents are not original enough to copyright, then by necessity edits to them are not. And so, it's sort of implicit in their own argument that the Idaho documents are copyrightable. But even setting that aside, UIRC has said to the court below that, number one, their complaint attaches some of that Idaho language and claimed copyright over it. Their interrogatory responses use some of that exact same Idaho language and claimed copyright over it. And they submitted it to the Copyright Office and claimed and obtained copyright over it. So at this point, UIRC can't be heard to say that it's not copyrightable. It's simply accepting the premises of their own prior representations to courts, and in fact, they're likely stopped from arguing otherwise at this point. And finally, the district court, it's kind of a related point, is allowed to use interrogatory responses and complaints to determine the scope of the claim, which is what the court did here. So that also prohibits an argument that somehow there's an implicit or a presumption of copyrightability of the Idaho documents, because UIRC has said that themselves in this litigation. So copyrightability of the Idaho documents is implicit in UIRC's own argument. So that brings us to the originality argument. We view the derivative work argument as frankly the easier route, because you can accept a lot of premises from UIRC, premises that we frankly disagree with, but you can accept them and still rule against them because at best it gets them a derivative work. But we also believe that Judge Gettleman was correct in saying that the language at issue here is not copyrightable. Importantly, I heard for the first time an argument today about redemption provisions. I haven't seen that before the court. There was no, here is the exact language we're talking about, court. There was an attachment to summary judgment that had a bunch of edits, but there was no, here's the exact sentence that conveys this argument so eloquently, and nobody could have said it, and it could have been said differently, this is what you should be looking at, and let me explain to you why this is so very original. There's none of that. Instead, we got, the edits are original, and so you should look at the edits. If you look at the Taflove case, which is cited in our brief, this court rejected a similar attempt to, after the fact, show how language could have been drafted differently. The Taflove case was about a case with scientists, and I have to admit the science was a little bit beyond me, so pardon me if I butcher the facts a little bit. But essentially there was a scientific paper about how particles behaved, a model about how particles behaved at the University of Chicago, and later work incorporated that model. And the copyright holder on the words describing the model said, well, you could describe that model a bunch of different ways. It's essentially the same argument being made here. And we're not trying to copyright the idea, which everyone agreed that they couldn't do, but we're just trying to copyright the manner in which we express this. And the court actually mentioned expressly in the opinion, yes, on appeal, they did list a few different ways in which you could, in theory, phrase this differently, but they didn't do it before the district court, and so it's waived. And if you look in the district court, you're not going to find, here's the sentence with the concept, and here's the 3 other ways you could have phrased it, and you didn't. You're just not going to find that in the summary judgment record. You'll find references to a different deal, but a different deal is not, here's the way you could phrase that. And if you look at the language, it's pretty clear why. Because the language is things like, if we get some funds, here's how we're going to apply them. They're very factual. You can't say, I'm going to apply these funds in the order of X, Y, and Z very many ways, while clearly expressing how you're going to apply the funds. And as we note in our brief, for very basic legal provisions like that, and I do emphasize, these are documents that are complying with regulatory requirements. A private placement memorandum is essentially a prospectus, but private. So you're complying with disclosure obligations, and the indenture is a legal document. It's kind of like a contract or something. It sets out the terms. And so in legal documents like this, you want to encourage people to be able to rely on kinds of language that courts understand, that lawyers have understood, so that there's no confusion among anybody. So if you look at these edits, they're things like that, things that both are and should be expressed only in certain ways. Other edits include fund names, changing fund names, changing singulars to plurals, changing defined terms from one defined term to a different term. I mean, these things are clearly not original enough to warrant copyright protection. One brief thing about the waterfall provision. Even now, even though the waterfall provision is expressly mentioned in UIRC's brief, they did not explain exactly what words in that provision are so creative, and why exactly those words could not be expressed another way. And so that also speaks volumes. And presumably, this should have been very easy for them to do both below and on appeal if, as they testify, they spent 6 months painstakingly drafting this purportedly new language. I'd finally like to address the argument that somehow the district court erred by looking at individual phrases instead of looking at the entire work. What is at issue here now are individual phrases, because they have and had to concede that large portions of the text over which they initially claimed copyright are not in fact copyrightable to them because they are not original to them. They were not drafted by them. So the copyright claim is over individual phrases, and that's the entire point. The district court surely did not err by analyzing the isolated things over which copyright is even arguably applicable to. Unless the court has any questions on Mr. Cult, the jury demand, or fees, I'm happy to give the remainder of my time back to the court. But I do request that if the court affirm the district court's order, and on in your opinion, if you could please extend the fee order to the fees on appeal. Thank you.
Thank you very much, Ms. Henning. Mr. Schultz, we'll go back to you and give you 1 minute for rebuttal.
No dispute, we went to the Copyright Office at the beginning and said, here's our stuff, we want a copyright. The copyright said, you want a copyright? The Copyright Office said, do you want a copyright over the whole thing? We said, nope, just the new language that we have, we're not claiming a copyright over the whole thing. The Copyright Office said, fine, gave us our copyright. Sure, the Copyright Office could have said, hey, spell it out for us. Tell us which is which so that we know. Copyright Office didn't, okay? Secondly, when Blair took our stuff and copied it for Rainier, Blair could have come to us and said, hey, we looked at your copyright and we noticed you never told the Copyright Office what you're claiming a copyright of and what isn't, and we know a lot of this stuff isn't copyrightable, so tell us where you really think you got a legitimate copyright claim and what's the boilerplate that we can copy. They didn't do that. They just took it and copied it and went. Third, in discovery, in this case, they claim, well, we still have no idea what's copyrightable. They went through this in deposition after deposition. They took both of the UIRC principles. They did a 30B6 deposition of UIRC. They took expert depositions. They took our lawyer's deposition again and again. What exactly are you claiming a copyright over? What exactly are you claiming a copyright over? It was spelled out for them in exhaustive detail. In essence, it's the stuff I talked about before. That's the heart of where the copyright is. That's got nothing to do with the Idaho document. There's no GSA properties and multiple properties in the Idaho document. This is all unique to our transaction. And then there are other peripheral provisions that are tied to that. That's the essence of the claim.
Thank you very much, Mr. Schultz.
Thank you.
Thank you, Ms. Henning. The case will be taken under advisement. We're going to move now to Appeal 22-1349. This is United States versus Christopher Truitt. And we're going to begin with oral argument from Mr. Leon.
Thank you, Your Honor, and may it please the court. This court should vacate and remand for at least 2 reasons. First, the district court committed a due process violation when it failed to order a competency hearing under 18 U.S.C. 4241. And second, the district court plainly erred when it failed to render 3 particularized findings under USSG 1B1.3 as to the drug quantity.
Mr. Leon, with regard to the sentencing, what should Judge Hanlon have picked up on at the sentencing time frame as to why a competency hearing was necessary?
So for the sentencing, I think we have 2 crucial things happening. One, we know that at that time, Truitt can think, reason, and understand only to the ability of a 10-year-old. That's undisputed medical evidence in the record. Second, we know that his counsel came up to the podium and said, Truett cannot remember strategic conversations with me regarding this sentencing hearing. And that's flat out evidence of an inability to meaningfully assist counsel. So those two things in combination, I think, combined with counsel's statement that his client may need to be put in a memory impaired unit in the BOP was a flashing alarm.
Well, the memory impair issue cuts both ways, right? Because obviously the court counsel for the government and defense counsel all are discussing this as part of the potential disposition. That the topic wasn't being hidden. The topic was right there for everyone. Isn't there a distinction between that and the topic is so strong that we can't go forward with the sentencing today?
Well, I think we have to look at the case law to answer that question. And this court has rejected trial counsel's view, the district court's view, and the prosecutor's view in multiple cases. And I would point the court to Graves, Anderson, and Brown v. Stearns, in which, and I think Graves is a helpful example, that was an Anders brief case. And this court remanded for a sua sponte hearing under 4241. And I think what's really happening in this case and why Truett slipped through the cracks is that his counsel had an incorrect view of competency. His counsel thought that if you are in touch with reality, you're competent. But being in touch with reality is not the same as being competent. You can know where you are. You can know that you're a judge, that I'm a defense counsel. But that doesn't mean that you can meaningfully assist your counsel. That doesn't mean that you can rationally understand the proceedings and make those few trial-related decisions that this court discussed in Newman. So I think that's why the district court should have picked up on something. And remember, the test here is not whether the district court had enough evidence in front of it to deem Truett incompetent. That's not the question here. The question is, was there a reasonable cause? You know, like, should a district court have paused here, maybe asked a few questions, could have had a preliminary hearing about what's going on with Truett, but it just held by those facts. And I think the change of plea hearing is, and I also, before I go to the change of plea hearing, I want the court to know that Truett's counsel never said anything about Truett being competent at the sentencing hearing. Neither did the district court, and neither did the prosecutor. So there's no statement here at the sentencing hearing that says Truett is competent. It's just passed by. But if you go back to the change of plea hearing, as I was mentioning earlier, we have a lot of undisputed facts that I think the court should consider. As I already mentioned, Truett thinks and reasons like a 10-year-old boy. That's undisputed. Second, Truett suffered a traumatic brain injury in 2016 because someone shot him 10 times all over his body. He developed MCI, and he even told the district court at the change of plea hearing, I have a lot of trouble remembering the past, and I don't know if that's affecting my ability right now. But that's not all. On top of those two, we also have Truett telling the district court before he pleads guilty and faces up to life imprisonment, I'm not getting my medications. The district court just moves by it. And that's not how you go into a federal district court and plead guilty to the crime that Truett did.
The district court follows up. The question is whether under an abuse of discretion standard there was enough follow-up.
No, so I think the standard of review here is comprehensive. Garrett squarely answered this question.
But that's de novo, is what you're saying. Comprehensive means you're telling us the standard of review in this case is de novo.
No, Your Honor, I'm not saying that.
What's the difference between de novo and comprehensive?
So this court has not explained comprehensive in detail yet, so the precedent doesn't really answer the question. But I think it is going to be less deferential than the abuse of discretion standard.
Why should it not be abuse of discretion? We routinely review matters very similar to this under an abuse of discretion standard.
I think, Your Honor, because this is one of the most important things that happens in federal courts, that a person walks up and knows what's going on. And in this context, we're not saying that it's always going to be comprehensive. It's for the change of plea and the sentencing. Because at this stage, the district court's not having much interaction with my client. It's a 30 to 50 minute.
There's a lot of interaction. And the district court asked your client a lot of questions to
That's right.
determine its competency. And maybe the judge could have asked more about the medication, okay? But the judge asked a lot of questions to determine competency, to figure out whether your client knew what he was pleading to, knew the allegations against him, knew the elements of the offense that the government had to prove.
So I do agree that the district court did the typical Rule 11 stuff. But Truitt's yes sir and no sir answers, as this court has said in multiple cases, they don't really elucidate his state of mind. And I think what does elucidate his state of mind is what he tells the district court. So the district court asks him, do you understand something about the advisory guidelines? Truitt responds right to the district court, I like you.
Yeah, but that, I mean, you're taking that way out of context, in my view. I mean, he said, he first misunderstood, he misheard the judge, and he thought the judge said revisory, and he said, what is that? I don't even know what that means. That's a good question, right? Then he was explaining, no, it's not revisory, it's advisory, meaning the judge doesn't have to accept it. And your client says, oh, I like you, judge. Yeah, I'd be happy with you sentencing me under advisory guideline range. That's what he's saying. We have this rapport, right? That's clearly what's going on. He's not saying, I like you in some other way.
No, Your Honor, I respectfully disagree.
What did you think he meant?
I think Truitt is very confused about what's going on at that hearing, and you can't just take that one statement and, out of context. This is a man.
But I think that's what you're doing.
No, and what I'm doing is considering who this person is before the district court. Before the district court, we know it's undisputed. This man thinks and reasons like a 10-year-old boy.
I don't want you to lose your time. The second point, especially with regard to the three elements, doesn't he still get back to base offense level 32? Tell us, give us your second argument.
Thank you, Your Honor. So in the second argument, the district court had to find three specific findings under 1B1.3. I think it's easy to conclude on this record that he did. So I think prongs 1 and 2 are done with, and prong 4 under plain error review is not disputed on appeal. So we get to prong 3, which is whether there's a reasonable probability that the sentence could have been different if the district court had rendered these findings. And I think there is here because of two reasons. First, Judge Hanlon put a lot of stock into the quantity here when he analyzed 3553A. He called it a large quantity, and if Truitt could have even gotten 5 months less, because maybe he was responsible for a third or fourth of this drug conspiracy, at least under relevant conduct, that is enough for prejudice. But even if you don't agree with the 3553A arguments, I think there's a reasonable probability his guideline range would be different. He gets to 30. And the reason is...
His offense level gets to 30, you're saying?
His base offense level would start at 30, I think, instead of 32. So he would get a -2 reduction, which puts him at a guideline range in which he doesn't get the sentence that he does now, assuming the district court gave him a guideline sentence.
Is that based upon some anchoring argument, or why do you think the sentence would have been lower?
Because I don't think he is responsible for at least 3.3 pounds of drugs, and there's a reasonable probability the district court would find otherwise. When Truitt made these phone calls, and that's his gist of the case. He made a few phone calls to a guy to give some drugs to his girlfriend. When Truitt made those calls, he was the middleman. That would be relevant conduct.
Well, that's disputable, by the way. That's disputable that he was the middleman. I don't think that's what this case was about. I don't think that's what the judge found. He was in the middle because he was in jail, but that doesn't make him the middleman in the drug transaction. And the judge could have found he's responsible for everything because he is the one that is running the drug trade.
So I think he is running it as to the drugs that he orders, Your Honor. So I put in my reply brief, I put a chart to show that there are really 3 lines coming from Corey Kelly, and when the line starts with Truitt, that would be relevant conduct. But when the line doesn't start with Truitt, there's nothing in the record to show that it would be relevant conduct. And even the government superseding indictment only ascribes less than 1 pound of meth to Truitt, and it has to show at least 3.3 pounds to get him across the threshold to get the base offense level of 32.
We're going to give you some rebuttal time, Mr. Leon. So thank you.
I appreciate it.
Thank you. We're going to now move to Mr. Wierenga.
May it please the court, Julian Wierenga on behalf of the government. I want to note initially that Mr. Truitt, both in his briefing and in his argument just now, refers to undisputed facts regarding Mr. Truitt's mental capability and function. And there were no judicial findings on that question. And so there were allegations and there were representations and there were medical records that were before the court that were relevant to the court's consideration of this mental capability issue. But there were not findings of fact from the court. So to characterize that evidence, the medical records and the allegations from Dr. Polly Westcott in the psychological report as undisputed facts is inaccurate with respect to this case. I wanted to address next the fine issue and with respect to the argument that it was not a mandatory condition of supervised release. And the first thing that I wanted to note is that from an equitable standpoint, this issue is prospectively moot. The Bureau of Prisons has been having Mr. Truitt pay this fine in $25 quarterly increments, and he's already paid $50 out of the $250, and he has another over 11 years left in his sentence. So on the current schedule, he will have fully paid the fine more than 9 years before he's released. So it's highly unlikely on the current schedule that this would ever come into play. The other thing that I wanted to note on the fine issue is that both Mr. Truitt and the government in their briefing have discussed the Sentencing Commission's determination that it is a mandatory condition of supervised release, the timely fine payment. And both Mr. Truitt and the government have noted that ultimately the Sentencing Commission's determination relies on 18 U.S.C. 3613A. And Mr. Truitt in his brief argues that the fact that 18 U.S.C. 3613A uses the term may in discussing whether the district court can revoke supervised release if a defendant, an inmate, fails to timely pay his fine. Mr. Truitt argues that the use of that may term means that it can't be a mandatory condition of supervised release. But the core statute regarding mandatory conditions of supervised release, 18 U.S.C. 3583, for the overwhelming majority of the mandatory conditions of supervised release that it discusses, it uses the exact same term. There's only a handful of mandatory conditions under which the district court has no discretion and must revoke supervised release. And so the use of the term may in 3613A is on all fours with the terminology that Congress has used in other instances where nobody disputes that it was creating a mandatory condition of supervised release.
Mr. Weyring, if you could address the competency at sentencing issue.
Yes, I think they're
and the reason I bring it up is his longtime counsel is this attorney Martin. Martin says there's 14 months between the plea and the sentencing. I've seen changes and they've not been for the better.
Yes, there's multiple reasons that there was no reason for the district court to have concern. The longtime counsel stated, I don't have any concerns. He made the affirmative representation at the plea hearing that there was no concern about competence. He was ready to go forward. He'd had a detailed discussion and he was confident that his client was competent. And obviously this court's precedent says that a lot of weight can be placed on the representation of counsel. And Mr. Martin never revisited that determination. He never raised it. He never said, I see these issues with respect to his memory. That leads me to think he can't meaningfully participate in these proceedings. And the other things that were before, in addition to Mr. Martin's representation, the district court had multiple things before it that would have allayed any sort of nascent concerns that it might have had. One of the things is just the nature of the crime. This is not a simple crime. It's an administratively complex crime. Mr. Truitt initiated a drug dealing business from prison, and he was ordering the drugs. He was arranging for the delivery of drugs. He was following up when people weren't paying for the drugs to make sure that payments were being received. And then in addition to that, there's Mr. Truitt's behavior at the proceedings themselves. And as Judge Kirsch mentioned, this is a highly engaged defendant. This is a defendant who's participating attentively. He's listening to the details of the proceedings, and he's reacting to them in a way that shows that he's fully present and he understands what's happening. So for all of those reasons, the district court had no reason for concern regarding competence.
You may continue.
I think on the drug amount issue, The one thing I would note is that Mr. Truitt makes a lot of argument regarding the, he does a close reading of the content of the indictments and argues that that somehow governs what happened here in terms of how much of the drug trafficking Mr. Truitt was responsible for. But the indictments don't control what the government would have represented at trial. And when it came to sentencing, Mr. Truitt repeatedly admitted directly himself to the court and also through his counsel that to the description that the government provided and that was contained in the PSR, stating that he was responsible top to bottom. He had awareness of everything, and he had oversight of everything. So there simply is no way, there's no suggestion in the record that under any reading of the facts and the admissions that he could have got below half of the traffic drug amount.
So play this out for us. There's Act 6 and Act 7. There's implication with regard to the pound and the 3 ounces. Put the 3 ounces to the side. With regard to the pound, you're indicating even if we were to disaggregate that from the remainder, he'd still be at the same base offense level?
Well, the accounts of the drug dealing that are relevant here is the summary that's contained in the PSR and what Mr. Truitt admitted to at the sentencing hearing and what his counsel described and what the government described and what Mr. Truitt assented the government would be able to show if the case went to trial. And all of those descriptions say that he was responsible for all of it.
Well, he does speak up at one point and say he doesn't know that one individual.
That's correct, Your Honor. There is one person, a bottom level dealer, that his girlfriend would have transmitted stuff to, and he says, I don't know about her, but everything else I agree with that the government has summarized. And in those summaries, the government is speaking comprehensively. There's no exclusion or limitation or suggestion that he had only a partial involvement. The final thing that I wanted to note is just with respect to the standard of review question on the competence issue, the government, of course, believes that that doesn't have any ultimate relevance to the analysis because under either standard, the district court reached the right result and there was no reason for concern regarding competence. I do want to note that in my brief, I said there was no case after 1991's United States versus Collins that used a comprehensive review. I did find one more in preparing for this argument, and that's United States versus Ross, 510 F 3rd 702, and that's from 2007. But it's nonetheless clear that the overwhelming trend of this court's jurisprudence on this question is to use the abuse of discretion standard. And one of the cases that Mr. Truitt relies on in his argument that this court somehow employs a bifurcated standard of review on this question is 2016's United States versus Stoller. And Mr. Truitt argues that that case appropriately used an abuse of discretion standard of review because there was a psychological report before the court in that proceeding. But in fact, Stoller precisely parallels the circumstances we have here where in Stoller, the district court's decisions were challenged in terms of accepting a plea and then its failure to order a competency hearing after the plea was entered and the defendant was considering withdrawing it. And at the time Mr. Stoller entered his plea, there was no psychological report before the court. There was after he entered his plea. At that time, his counsel obtained a psychological report. And in Stoller, this court reviewed both of those phases under an abuse of discretion standard. And that's exactly the circumstance we have here, where there was not a psychological report before the district court at the time Mr. Truitt entered his guilty plea. But after he entered his plea, his counsel obtained a report from Dr. Polly Westcott, and he cited that report in his sentencing submission, and he cited it repeatedly in his brief. And so Stoller, in fact, supports the application of the abuse of discretion standard under both phases of the decision-making that is at issue here. Unless your honors have any further questions, the government rests on its brief and asks that the court affirm the district court's judgment.
Thank you very much, Mr. Wierenga. We'll now move Mr. Leon to you. I'm going to give you 3 minutes.
Thank you, Your Honor. A few points in response. First, the government says that trial counsel at sentencing said nothing about competency, but that's because he was using the wrong tests. Why would he say anything about competency if he's conflating being in touch with reality and competency? So I think that's why trial counsel said nothing at the sentencing. What he did say at the sentencing was potent. He said, this is the lowest functioning client that I can remember in my career, and that he can't remember what I'm telling him in regards to what we would talk about at the sentencing hearing. That's prima facie evidence of not being able to assist his counsel. If someone can only think and reason like a 10-year-old and can't remember what his counsel is saying, that's reasonable cause. But if the court doesn't want to write the opinion on competency or write the order on competency, there's another reason to reverse and remand here, and that's the drug issue. And if the court does reverse on that issue, guaranteed Truitt will move for examination before resentencing. And I want to point out the government says that the drug amount would be the same no matter what. But the government gave the same base offense level to every person in this conspiracy, and then it got them to waive appeal, all of them except Truitt. What happened here is the government picked a number and didn't apply USSG 1B 1.3. Truitt is the only person who could appeal, and he has pointed out this issue, that no one applied the correct guideline provision. And there is evidence, or at least an indication of a reasonable probability that his guidelines range would change. We have the superseding indictment. The government says, well, maybe we didn't put everything in the superseding indictment. But everything Truitt did here was based on a phone call. I don't think the superseding indictment is going to leave out the haymakers and then just put in the minor details that Truitt did. And last, talking about the fine issue, the government says that Truitt will have paid this fine in 10 years, but not if this court vacates it. He won't have to pay anymore. So the issue's not moot. And any evidence the government talked about up here about the BOP is not in the record and should not be considered. For the reasons in the brief, I ask the court to please vacate and remand so that Truitt can see a doctor. It doesn't matter whether it's under the competency issue or the drug issue. Thank you, Your Honor.
Thank you, Mr. Leon. Thank you, Mr. Wairenga. The case will be taken under advisement. We're going to now move to the last case of the day. This is Appeal 22-3024, United States versus Tovar. And Mr. Bell, we're going to begin with oral argument from you.
Thank you, Your Honor. I'm going to ask for leave of the court to allow me to put my cell phone on.
Absolutely.
It controls my hearing aids.
That's fine.
There's an app for that. May it please the court, as the court has announced, I have the privilege of representing Mr. Tovar. I represented him through sentencing at the district court level. This is the second appeal in which I've attacked United States versus Ruth on the tax. It'll come to me when I'm driving home. Anyway, I'm not going to argue that. I found Justice Sotomayor's and Justice Barrett's memo very interesting. I think I referred to it. It merely says it's the commission's responsibility, so it looks like that's going to be the fight. I find it offensive because it is so diverse. Because depending on what district you get arrested in, and depending on what state you had your prior, you may hire, you may not, you may get the enhancement, you may not. And that's unfair, but I can't solve that here in the Seventh Circuit. So I want to talk about the second issue I had, which was the conversion of the cash into marijuana equivalent. Now, the problem with that is, the standard is kind of a loosey-goosey standard, I thought. Let me get my notes. When there is sufficient basis to believe that cash found in the defendant's possession was derived from the drug sales, the court properly includes the drug equivalent. Now, we don't even have any marijuana sales in this case. we do have at least 2 cocaine sales, but they were for very small amounts. The cocaine in total, I think, was 5.1 gram. Marijuana was more than that. So there's other things that you need to look at rather than, well, if there was a sale, it must be it. He didn't get that much money in either of the purchases or the sales that were controlled. He got $26,000 a year earlier from a legitimate source. Now, so credit unions are not going to lend him $26,000 unsecured if he doesn't have a significant way of showing to be paying it. Okay? So he's got some lid somewhere. And where it is in those cars that he was buying at auction and selling to make money. He would buy them at auction, he would improve them, and he'd take them to this dealership and have them sell them. Now, the pre-sentence investigation report writer called that agency, or wrote to him, I don't know how she contacted him, and that automobile dealership said, he's not employed by us, but he buys cars, he fixes them up, he brings them here, we sell them, and we have to sign the papers. And that's in the pre-sentence investigation report. So that's a legitimate thing that he could earn the money. And so to jump to the conclusion that just because there's money in the house, we are simply making it illegal to have cash in your house. I mean, it's just crazy, in my opinion. The court needs to look at that. Why can it be so diverse? He had a source of income. He had a legitimate loan. So our position is that that's not, that this standard is kind of different than what I'm used to. I'm used to probable cause and preponderance of the evidence and so forth, and the court nodded. I'm not used to sufficient to believe, basis to believe. Now, the problem with sufficient basis to believe, it's so loosey-goosey. Is there a sufficient basis to believe an election was stolen? A lot of people say yes, a lot of people say no. What kind of standard is that? So we object to the standard, and we think that given his legitimate source of income and the fixing and selling cars, which was verified by the agency, should be sufficient to challenge the sufficient basis to believe. So we think the court incorrectly converted $38,000 into marijuana when there was a valid reason to have the $38,000. Now, it is a little unusual that he didn't put it in a bank as opposed to in his house, but some people don't trust banks. My grandmama put her money in the mattress. So draw your own conclusions about that. With regard to the second issue I want to address is the refusal to allow Mr. Tovar to withdraw his guilty plea. The interesting thing about that is he had an attorney for a long time, court-appointed attorney. And he was dissatisfied with him, with her, I guess. She was from the public defender's office, federal defender's office. He was dissatisfied with her, and the family hired privately another attorney. And as I calculated, 8 days later, he walked into court, pled guilty to every count without a plea agreement. How effective can an attorney be with a situation like this in 8 days? Okay? Now, he wanted to withdraw his guilty plea because he thought that he could show that he was legally innocent because of a threat he received. At page 5, I think it is, of the appendix, you will see a text message he received, or I think his girlfriend received, and it shows automatic with a magazine, bullets in it, R.I.P. Michael and Romello Tovar. looks an awful lot like a threat to me. And it's a threat with a gun. Under those circumstances, shouldn't he have been able to own a gun to protect himself? There's case law that says that. And we're saying he should be able to do that.
Would you like to reserve the remainder of your time?
Yeah, I got 37 seconds now.
Oh, very good.
Okay. So that's the argument on that. Your Honor, I think I will save the rest of it.
Very good. Thank you, Mr. Bell.
Thank you, Your
We're
Honor.
now going to move to argument from the government. Mr. Simpson.
Thank you, Your Honors. May it please the Court, I'm Scott Simpson on behalf of the United States. I'd like to point out a number of things from Mr. Bell's argument. First of all, the amount of money involved here is $38,916. The standard of review for the district court on that, the standard that the district court is supposed to look at on that, true, is whether there is a sufficient basis to believe that the cash found in the defendant's possession was derived from drug sales. I disagree that that's a, quote, loosey-goosey standard. That is the standard. The fact that it isn't more fleshed out, that it isn't more, that there aren't a number of steps to that standard, indicates that it is an easy standard to meet. It is a pretty low threshold. And of course, the standard of review for this court is also pretty low. That is clear error. And we believe there was more than sufficient basis to believe that that money was from drug sales. He was carrying hundreds of dollars when he was arrested at the bar, and hundreds of dollars in cash and cocaine packaged for sale. In his house, the police found the rest of his drugs, the rest of his cash, the tools of his drug trade. Specifically in his bedroom, he had some of his marijuana and cocaine. He had one of his scales for weighing drugs. He had also in the bedroom inositol powder for cutting the cocaine. He had $5,000 in a jacket pocket in the bedroom closet, $3,500 more under a vent in the bedroom, and his pistol and ammunition for the pistol, all of that in the bedroom. And elsewhere in the house, he had the rest of his marijuana and cocaine and another scale. Now, I want to make sure that that this court is clear. This is reflected in the lower court's record, but just to put it in the argument here, the total amount of cocaine found in Mr. Tovar's house was 29.7 grams of cocaine. The total amount of marijuana was 164.4 grams of marijuana. Clearly distribution amounts of both of those drugs. And at the plea hearing, when the district court asked Mr. Tovar whether the gun was near the drugs, Mr. Tovar ultimately admitted that it was. Now, on those documents that the defendant submitted below to try to show that the cash came from legitimate sources, there are basically two categories: bank statements and documents showing purchases and sales of vehicles. As the court observed, Mr. Bell pointed out that apparently Mr. Tovar allegedly didn't trust banks. Actually, those documents that he submitted showed that he trusted banks, at least to transfer funds. That's apparently what he was mostly doing, using banks for. The bank statement suggested that he liked using banks to transfer money. But nevertheless, as the district court pointed out, he was keeping $38,000 in cash in his house. Another interesting point on those bank documents is they show deposits made in the Quad Cities area, but most, or at least a large number of the withdrawals of cash shown in those bank documents were made elsewhere, in Laredo, Texas, on the Mexican border. So Mr. Tovar apparently didn't have most of the cash that had been put into those bank accounts or credit union accounts. Someone else had gotten that cash out, a lot of that cash out in Laredo, Texas. And the vehicle documents that show the sale and purchase and then sale of vehicles, yes, they showed that Mr. Tovar bought some cars. We don't know how he got the cash that he used to buy those cars. Those documents show sales of vehicles, but they show sales of vehicles made by a dealership without Mr. Tovar's participation. The bottom line here on all those documents, Your Honors, is they show some cash changing hands. They show some vehicles being bought and sold, but none of those documents actually show how Mr. Tovar got his cash. And also, one more point on those vehicle documents. If you look at the purchase prices and the sale prices on those documents, it looks like the average profit on each car was a little over $1,400. So Mr. Tovar would have had to have sold an awful lot of cars, assuming he was selling cars in his own name at all, to make more than $38,000. So definitely the court did not commit clear error in concluding there is a sufficient basis to conclude that the cash was from drug sales. A few points, if I could, about the other issue, the evidentiary hearing issue. I was a little bit surprised to hear Mr. Tovar's attorney. I believe the language was that Mr. Tovar was challenging the denial of his request to withdraw his guilty plea. That's actually not true in this appeal, at least. Now, in the court below, he never actually moved. He never actually filed a separate motion to withdraw his guilty plea. He did put in his sentencing memorandum, I think it was, he did say that the court should allow him to withdraw his guilty plea. But in any event, if you look at the defendant's brief here, he actually is not challenging the denial of a request to withdraw his guilty plea. The issue here is only the district court's denial of his request for an evidentiary hearing. And there was certainly no abuse of discretion in that because, among other things, the district court actually accepted Mr. Tovar's factual assertions in support of that request to withdraw his guilty plea. The court just said, even aside from all of those facts, I still don't think there's any basis here to withdraw the guilty plea. So obviously, there would have been no reason, there would have been nothing to discuss at an evidentiary hearing because the defense did put on some facts, they did submit some documents and so forth in support of being able to withdraw the plea. But the district court said, okay, I accept those facts as true, but I still exercise my discretion to say we don't need a hearing here, and so a hearing could have added nothing. So for all those reasons, Your Honors, we urge the court to affirm Mr. Tovar's conviction and sentence.
Thank you very much, Mr. Simpson. Mr. Bell, we'll move back to you for rebuttal argument.
Thank you. May it please the court. Excuse me. I wanted to address distribution amounts of controlled substances. We don't have large amounts. We don't have big transactions. They're, sale in a bar is what happened. It's not like we got a kilo or 4 kilos or half a pound. It's 1.4 or something, 1.7, something like that. So it's not big sales. It's not a big contract, as you would get at the top of a conspiracy where they're bringing in whole amounts, or even further down on a conspiracy. So our position is that the court should have given us a full-blown hearing on a motion to withdraw so we could have put on a full evidence and demonstrate that he had a legitimate defense and that because his second attorney only represented him for 8 days, they didn't have enough time to really hash that out and decide. And, any attorney can talk their client into pleading guilty. It's not hard. I've done this 35 years, and I can talk them into if I want to. I won't. I won't. I'll give him this options and say, do what you want, here's what happens. But I particularly know this attorney, and I'm not aware he's ever done a trial. That might be an issue. It might be an issue as ineffective assistance to counsel. If he's using his position to tell the guy he's got to plead guilty. And I've seen it done. So that's the concern. 8 days just drives me crazy. I can't get anything done in 8 days with a criminal case this size. 7 or 8 counts, guns, drugs, search warrant, all of that. I can't do it. So that's our position, that he should have been given a hearing so he could put on the full information, and that the cash should not have been converted.
Thank you very much, Mr. Bell. Thank you very much, Mr. Simpson. The case will be taken under advisement, and that will end the court's hearings for the day.